Welcome again to this last lunch talk and the series Data Power Law. This is a lunch talk series organized by the Chair for Public International Law and Human Rights Law. This is the chair of Professor Nora Markert here at the University of Münster. And it is a cooperation with the feminist association Netzfarmer, who advocates for feminist internet and technology, and which is also the editor of an anthology which was just published this year, which is called If AI Then a Feminist One, or in German, Wenn KI dann feministisch. And in this series, we talked since May about database technologies, power relations in and through technology, and the role of law in this. And we have talked in our first lunch talk about the effects of datafication on concepts like equality, autonomy, and democracy. We've discussed, amongst others, with the member of the European Parliament, Alexandra Geese, on the Digital Services Act and hate speech. And we've learned last week from Petra Molnar about the use and the impact of border technologies on people on the move. So we've heard a lot about the wrongs and risks in case state actors or private actors deploy database technologies, including those technologies which are based on big data, artificial intelligence, machine learning, and all those relative methods. And there might come up the question if there is in any event a way to achieve justice through those database technologies. And if this is something which we could actually ask from private tech companies who develop and deploy AI systems. And, or isn't it just AI, just technology? And what does justice mean anyway? And all those concepts like justice, for instance, or also trust, are kind of just dropped in this discourse around the regulation of AI technologies. And there are many different approaches and understandings towards those concepts. And therefore, in this last talk, which is entitled Just AI, we will our Associate Professor Lynette Taylor will share with us her thoughts on the question whether there are ways to govern AI technologies when different groups are locked in opposition around those core concepts and assumptions which each other consider non-negotiable. I'm very happy to welcome Lynette Taylor as our guest today. She is Associate Professor at the Tilburg University's Institute for Law, Technology and Society in the Netherlands, and she leads the ERC Global Data Justice Project. Her research focuses on digital data, representation, and democracy with a focus on transnational governance issues. And actually, I can recommend all her papers, also the one work about group privacy, but especially I like one of the last ones, which is also relevant to the talk today, which is entitled, or the short title, is Public Actors Without Public Values. So without further ado, the floor is yours.
Thank you so much, Victoria. Hi, everybody. Thank you so much for inviting me today. I'm looking forward to talking to you about the work that I've been doing on what would constitute just AI on the international level. It doesn't refer specifically to the EU at this point, but I'm interested in your take on what this means for us in the European Union. So without further ado, I will attempt to share my screen and hope this works. So this is a topic that I work on with my team on the Global Data Justice Project. We're endeavoring to take an international, if not global, look at what good data governance means in a world where it's not entirely clear how the motivations of different countries and regions can or should match up with each other. So this comes from a background of trying to reconcile deeply conflicting and competing interests between different actors on the international scale, in a realm which has not traditionally been the prerogative of international law. So I'm very interested in the response of this audience on what they think that it means for international law. So to start with a couple of provocations. One is that we cannot have ethical AI without developing a politics of AI, and that we haven't done that yet. And that the current politics of AI that we have make a justice-oriented governance model unattainable. And third, that what we should probably do in response to that, and the we here is a global we, not a European we, is that we should connect AI governance to a pluralist democratic process, or more pluralist at least, and that we should support this by also separately building new norms for data on the international level. And I'm going to talk a little bit about both of those things today. I would contend that the current politics of AI are characterized by a high degree of political and regulatory capture, partly through sponsorship by big tech, and by expert-led processes of responsibility and ethics, which could usefully be conceptualized as just one in a constellation of possible approaches to governing AI. So to go briefly over the issue of sponsorship and capture, this is an interesting problem because we see it in front of us all the time, and we often miss it. Partly because big tech is very skilled at capturing popular narratives about how it is already part of our governance in general, and how it has structures which render it as governable as anything else. Whereas in fact, this is not true. I'm sure everyone here is aware of the discussion about how Facebook now has a Supreme Court. It's just put the idea out there that this body replicates the work of the Supreme Court and has let the press and popular imagination run with this, to the point where people will actually refer to Facebook's Supreme Court as if this were some kind of, judicial body, which I find rhetorically interesting. It very much involves people in playing actively to Facebook's interests. There's been a ton of debate in the media, particularly in the popular press, about what it means, what the decisions of this body mean. And this has completely distracted attention from the fact that this is not a judicial body. Facebook is not governmental, at least not in organization, maybe in character. And there is no way for people to democratically control what Facebook does at all. It's simply not designed that way. So big tech is also very involved in capturing political space. This is basically an ad for Microsoft's Executive Briefing Center in Brussels, euphoniously named, where Microsoft is putting an awful lot of effort into establishing and growing its relationships with policymakers in Brussels around the fact that in the EU, we are currently passing various laws to do with data protection and regulating AI. Capturing the regulatory process. This is from the US this time. This is, oh no, sorry, this is not. This is in Europe. This is the in-house lobbying budget with relation to the EU of the sort of big five of big tech. And as you can see, the individual changes since 2014 are only huge in the case of Google and Facebook, which reflects their growing power over that period. But overall, big tech's increase in their lobbying budget in the EU is absolutely huge. This is Lina Khan, who I'm sure you've heard of. She is the proposed FTC chair in the United States, proposed by the Biden administration. And Amazon has been pushing back against her appointment on the basis that she is an academic, she is a lawyer, who has written that Amazon and Facebook are ungoverned and anti-competitive currently. And so they are trying to capture the process by saying that the fact that she has ever expressed an opinion on them and that she is a highly qualified lawyer on these issues means that she cannot be a regulator. Here is Thomas Metzinger, who a couple of years ago in 2019 went public about the fact that he felt that the EU's own process was being captured. He said that out of all of the people on the EU's high-level expert group on AI ethics, which was the process 2017 to 2018, which preceded the writing of the AI Act, of which we currently have what seems to be a final draft, potentially, that there were 52 experts in this 2-year process, of whom half of them were business representatives, 17 were academics, but only 4 were philosophers. And this was an ethics process, and 11 were from civil society and others such as rights agencies. The reason that he was going public in Der Spiegel about this is because the committee initially recommended in the first draft of their advice that there should be red lines for AI around things like lethal autonomous weapons, around covert AI, around scoring and citizen scoring and contravention of fundamental rights. And that this was taken out of the final draft because corporate representatives and academics who sympathized with them because they were either economists or otherwise aligned with the corporate sector disagreed that there should be any red lines for AI. This was a complex discussion. I'm not doing it justice here, but his contention was that this process had been captured, and that's what I'm trying to highlight. Turning exclusively to academia now, we find that our own processes in terms of the advice and the insights that we try to offer to regulators on big tech are also being captured. This is famously now the Amsterdam Privacy Conference in 2015, where the sponsors included Facebook, Palantir, Google, and Microsoft, which are widely felt to be privacy violating firms, and that this was inappropriate for them to be sponsoring a privacy conference. This blew up very badly in 2018 when a bunch of scholars pulled out of the conference, including my own group, and started a group called Funding Matters to try to organize support for the idea that privacy violating companies do not belong in the same forum as human rights lawyers, basically, discussing a critical approach to technology and to regulating technology. Here are two academics from the US at MIT writing a paper on how they would like to compare research on big tech to research on big tobacco during the 20th century. And they look at the extent to which the academic space for thinking about big tech and regulation has been captured, where big tech firms are sponsoring a huge proportion of the tech analysts at prominent universities. And these are not just technical experts, but legal experts, sociological experts, anthropologists working on technology. It is becoming easier and easier to get sponsorship from big tech if you work on anything that is relevant to regulation. Moving on, the other framing for how we should do AI, other than in alignment with the wishes of big tech, is in alignment with these sort of formulations of responsible data and AI ethics. Now, please do not hear me as saying that I think we shouldn't have ethical AI. I think we should. I think there is a debate about how we get there and who does it. And it's very important to have that debate. And there are definitely opposing positions on how this should be done. Where did we get this framing about responsibility, which is in itself fairly light touch for a technology that is going to be so deeply affecting all of our societies, and already does, in fact, in many places in the world? Well, for one thing, this is an updating of disciplinary norms, because computing disciplines don't have a history of ethical codes and review relating to human subjects. For another, it answers public policy concerns as tech becomes increasingly involved in social policy and increasingly publicly visible without having systematic ethical frameworks. And third, it consolidates that power. Actually, it offers a vision of regulated big tech and of technical expertise in the academic sphere, which doesn't necessarily exist, I would contend. What does this responsibility discourse consist of? Well, one is pretty much a bare bones compliance approach, where we translate the language of ethics into data protection language. And the second is a preoccupation with these central concerns of fairness, accountability, and transparency, which themselves start from a compliance approach in relation to US discrimination law. This is a direct quote from a computer scientist in a meeting this year, who felt that, as many do, in fact, and I hear this all over the place, is why I quote this person, they're representative of a wide variety of technical experts who feel that they're being asked to do things which they're not equipped to do when they're asked to consider the social impacts of data and AI. This is a problem because computing sciences are relatively isolated in terms of considering the ethics of what they do. Computing experts don't have access to a lot of resources to figure out the ethical impacts of the technologies they develop, or to debate those ethical impacts, in fact. Societal problems instead tend to be framed in the form of requirements engineering. What must we do? Rather than why must we do one thing rather than another? And where should we stop? And when should we not apply AI in the first place? Even if we zoom out to research ethics in academia as a whole, it's not well equipped to deal with the political problems of recognition and representation that I'm going to contend that AI presents us with. One example of this is how fairness is being interpreted in relation to AI. These are two interpretations of fairness. The first one is about efficiently distributing energy and resources within a system so that it works optimally. And this is a quote from a computer science paper, the variability and blocking probabilities experienced by connection requests between various node pairs, which really subsumes ideas of fairness in relation to justice into a purely engineering interpretation. Obviously, this makes sense if you're a computer scientist. Here is another interpretation of fairness as an intersubjective problem of justice, equality, with continually changing goalposts. Here's an example of that. Ruth Bader Ginsburg was asked how many women on the Supreme Court would be enough, and her answer was, when there were 9, because for most of the country's history, there were 9 and they were all men, and nobody thought that was strange, she explained. These are very different views of what constitutes fairness. One is historicized, one is compatible with forms of redistributive justice, which would be more pluralist and understand perspectives such as the feminist perspective. Another is very much derived from the physical sciences and is about the distribution of electrical power and computing power within a system. These two things are not especially compatible, and yet this is the debate in which we live when we talk about fairness. 2 points of view on fairness that characterize these differing disciplinary approaches. One is that fairness must be formalized because that provides a target for creating standards and requirements so that systems can be regulated. Also because actually this contestation, this search for conceptual clarity between different disciplinary views, makes the discussion more inclusive of technical disciplines and applied legal perspectives, which are actually very important to preventing problems with AI in the world. Alternatively, we have the point of view that fairness must not be formalized because it doesn't tell us anything about whether a particular application should be deployed at all, at least fairness in its current form. We can ask all the right questions of an application and those deploying it and still remain within a framing that is overall unjust. One example of this would be the Siri debate, which has happened in the Netherlands recently, where a system for determining whether applicants for welfare, or rather utilizers of the national welfare system, displayed flags, red flags for fraud, was actually a court in the Netherlands decided this system was illegitimate and struck it down last year. But it had existed for 7 years before that and was originally okayed a decade back by both chambers of the Dutch parliament, making it officially politically legitimized. It also took in every single person who was a welfare recipient in the Netherlands, which by the current rules of fairness in computing actually make it a fair system. As long as everybody has an equal chance of being selected, then you can start flagging people for fraud and you can claim that it's fair. So it considered all claimants equally. It was accountable to central government throughout every phase of its application and deployment. And it was politically legitimized by both houses of parliament. And yet it was a profoundly unjust system, which was struck down by a court. This means, in effect, that the formalization of the standards and requirements such as fairness do get used strategically to distract society and legislators from more fundamental issues, such as justice. And it seems strange to talk about an opposition between fairness and justice, but this is the paradox in which we currently find ourselves with relation to AI governance. Because responsible and ethical AI in their current form are simply not adequate to assure us that we have just governance. Here we find issues of real contestation around particular things. First of all, interventions where challenges to the system are impossible or ineffective. Second, interventions that contravene scientific evidence. Third, systems that optimize for illegitimate outcomes. And fourth, systems and infrastructures that impact negatively on our collective future. For instance, around unsustainable computing or the reforming of labor markets into precarious engines of precarity, basically. And these things are discussions about red lines and legitimacy, but on the level of democratic process. They're not just about value-based AI, value-sensitive AI, and shaping the technology in the right way. They're about whether certain technologies should be applied or not in the first place. There's a problem with this contestation, though, in that those who are doing the contestation from a justice perspective are being delegitimized as having bad manners, essentially, as being too political in a space which does not welcome politics. There is a problem with being political in academia. There is a problem even with being political in corporations who are developing AI. And this is Timnit Gebru in the picture. She was famously fired by Google last year after she revealed concerns not only on the company's diversity, as this quote from the media says, but on the existence of Google's work on large language models, which she said cannot be put right because they create effects in terms of unsustainable computing on the global climate, which will be borne by people who do not benefit from the large language models. So there's a distribution problem there of costs and benefits. And also because, as Timnit Gebru correctly says, language cannot be put right. Language is discriminatory because the world in which we live and speak is discriminatory right now. We have structural injustice in the world, and that is reflected in language. And so no matter how large the database is from which language recognition models function, you cannot set it right. You cannot debias the data. The main thing that I wish to point out here is that even though her conclusions were not per se contested in the world, they were contested by Google, but they seem to make sense to people out in the world. People in her own discipline of computing sciences were very uncomfortable with her expressing opinions which seemed to them beyond the conventional realm of fairness, accountability, and transparency. They didn't like that these things were not bounded, that these things were not about debiasing the data and doing requirements engineering. They didn't like that they were broader justice claims. Examples of these broader justice claims come from projects and movements which are trying to connect AI in the data economy to social justice concerns, including civil rights, precarity in labor markets, criminal justice, housing, welfare, the list goes on. So these contestations do exist, but they're occurring outside of the corporate and governance sphere largely. Within the corporate sphere, but in contestation to it, is also employee resistance. We've seen large-scale employee walkouts and protests around gender and racial discrimination and harassment, political engagement on certain things or disengagement from other things by tech firms where people work, environmental sustainability, the precarization of labor, anti-union activities, particularly by Google and Amazon. And all of these are bringing politics into a sphere where it didn't really previously get much play. And finally, this idea that debiasing the data is not enough, that we need to have, for instance, feminist data justice or design justice, feminist values in design, is very contentious in the field. This is very openly spoken of in the world outside, but in the computing field, it is hugely contentious to talk about ethics, societal impact, and politics, precisely because these issues are overwhelming the field right now. And there are two options. One is that the field engage with them and be overwhelmed. And the other is that they deny that they have a place in the field, which is currently considered the way to go. It is much more convenient. Why is the problem of justice so unmanageable for technology and for AI in particular? Nancy Fraser has talked about how, in general, the framing of justice claims has been disrupted by globalization, so that deviation becomes less the exception than the rule. She talks about disruptions in a variety of spheres, including geography, the subject of justice claims, the who is determining what is just, the who of justice claims, the nature of the redistribution or redress that is appropriate. It is much broader, and which social cleavages can be the site of injustice. And as we look at this is a challenge both for societies as a whole and even more so for the tech industry, which has not traditionally been in the business of redistribution and justice, and suddenly finds itself positioned there. So Fraser tells us that we need three responses to this. recognition, representation, and redistribution, which are familiar terms to anyone who has studied questions of global/local justice before. But the idea of recognition and representation are precisely what is at stake if we want redistribution. If we cannot recognize political contestation adequately, we cannot get to the stage of redistributing power in an appropriate fashion. So what is the problem with governing AI in particular here? It's that we tend to look at the technology rather than the social problems. If we instead look at protest as a feature rather than a bug, we find that democratic governance may already be occurring and being resisted all around us. And second, that the challenge for governance and regulation researchers is to help frame this argument for an inclusive understanding of democratic governance, where the politics of AI can be included rather than excluded, because only then can we have engagement. How to do this? Well, one is to continue protesting and to grow the protests, which is what is currently happening, until they constitute what Bonnie Honig would count as inoperativity, through walkouts, through obfuscation processes within particular technological systems and manipulation of those systems so they don't work correctly to diminish the power of big tech over society. The other alternative is what Chantal Mouffe would call mobilizing protests towards the promotion of democratic designs. And here is where it gets interesting, because what are the conditions under which protest against AI and technologies in general can lead to pluralism and agonistic democracy? To do this, we would need to move contestation from an antagonistic perspective, which is where it currently is situated, to an agonistic one. From seeing people who contest the tech as the constitutive outside, as the enemy, to seeing it as an adversary who must be included in dialogue and in discussion. This is further complicated by the legitimacy problem of technology. Victoria mentioned a paper of mine at the beginning on legitimacy of public actors who happen to be corporate. And I would contest that we're seeing this all over the place, rather than the public-private partnerships that very much characterized the neoliberal approaches to building our economies over the last century. We're now seeing tech firms particularly set themselves up as public actors, regardless of government. For instance, Facebook's influence on electoral politics. WhatsApp has recently been named as the global public health information distributor by the WHO. And Amazon has become an official public health information distributor in the UK through Alexa, with the right to process NHS data from the National Health Service there, and to make profit from it, importantly. So there's an acknowledgement in all of these things that these are commercial infrastructures following commercial ends and motivations, but that they are free to pursue public attention and to gather market share in relation to public sphere activities and public services. This is new. We don't have the tools really to deal with this yet. We have data protection, which cares about individual identifiability mainly. We have, as I've marked out here, we have data ethics and responsibility, which doesn't aim at social impacts per se, it aims at requirements engineering. And third, we have claims around consumer trust, which I'm sure everyone here also recognize, which are in fact based on a thin version of business legitimacy rather than actual political legitimacy, which I would argue is a more appropriate question to ask of companies such as Facebook and Amazon currently. Would a pluralist approach to governing AI increase the possibility of actual thick interpretation of legitimacy in relation to these companies' activities, is the question. Here's a normative proposal as I draw to a close. There is currently an international norm being established around data by all the powerful actors in the world. States, coalitions of states such as the G20, the World Economic Forum, the World Trade Organization, parts of the UN, are all trying to establish the idea that data can, of course, be fully commoditized. It can be separated out from individuals. It can be treated as de-identified and anonymized data, and it can be traded as a commodity. This norm is actually being established using legal instruments, of course. India is proposing a non-personal data act to define large amounts of its data as public interest data, which can then be paid for from the companies that generated it and brought into the public sphere in order to create new markets and to feed startups in particular and to feed AI. The EU Data Governance Act says something very similar. The US has a ton of legal decisions we can see privileging unrestrained market dynamics around tech, all of which imply that the data market is the way forward. The data market is the future, that data should not remain attached to individual or group interests. Here is my question. What if we rejected this norm? What if we rejected the very premise of the norm and said that data is not a commodity, data is an aspect of individual identity, and that it remains so no matter what happens to it? Here is the difficult thing. What if we propose an alternative norm where data continues to reflect the interests of those that it represents, who may not be those who consciously generated it, but those it represents at any rate, along its entire life cycle, including once it is de-identified, including once it's defined as public interest data, including international data sharing, including scientific commons, and trade in different domains? If we did this, what would it mean practically? It would have huge cascading effects on the formulation of data protection, on the utility of data protection, in fact, as an instrument for protecting what we find valuable. For instance, it would be much harder to define what constitutes non-personal data until we move into the realm of purely physical processes. You know, astronomy data is non-personal data, but it would be very hard to say that you could fully anonymize and de-identify data and have it just travel around the world as if it didn't relate to people or groups. Second, it would affect how we organize political processes that determine the uses of data. These, as I pointed out in the part of my presentation about a justice-oriented form of governance earlier, would have to become more plural and inclusive. And we'd also have to follow the thread of the importance of individuals and groups generating data across trans-jurisdictional, transnational boundaries. And finally, this has implications for who can govern data, because it would mean that international fora could not actually regulate trade in data as they currently propose to, in isolation from states and subnational intermediaries. Data ceases to behave like orange juice or pork bellies or coffee and starts to behave more like people. So perhaps the regulation of migration is not a great example, because we tend to regulate migration as if people were not involved. But we would have to think about trading in people rather than trading in data, and this would necessarily affect almost everything that we think about when we think about sharing and trading data. And with that, I will stop and I will welcome your questions. Thank you very much.
So thanks a lot, Leonard, for your presentation. This was really interesting, and I have now some questions, like to recapture a little bit what you just said. And this would be the first one, is on the power of private actors, because you just said that they have a lot and that they need to legitimize its use also in the public sector. And maybe you could state again why this power of those tech companies is different from other private actors. I think this might be also interesting for German lawyers who think a lot about the binding of private actors to fundamental rights. And I think that now with tech companies, we have a shift in power. So maybe you could say something on this. This would be my first question.
Sure, thank you so much. So some of this, I would refer people to my paper on legitimacy, but I start that paper by defining my terms and saying that instead of just public-private partnerships, as I mentioned in my presentation, we can see maybe three classes of concern in relation to technology corporations acting in relation to the public. So one is the traditional public-private partnership, which, although there are always issues that we want to look at in terms of accountability and transparency with contracting, we can at least in theory hold the government responsible at whatever level is appropriate for the actions of the corporations that it contracts with particular services. So if the government is contracting with, for instance, Microsoft to provide all of its computers, and those computers start to behave in ways that are detrimental to the public interest, we can go to government about that. We will know it, and we will hold our representatives accountable. Then we get a second scenario, which is a sort of hybrid scenario, which is like a PPP but isn't. An example of this is the sort of super apps, for instance, that we're seeing develop around COVID in Southeast Asia right now, where you get companies that were already operating in the technology sphere and have a lot of capacity and infrastructure, bringing that capacity infrastructure to bear on, for instance, contact tracing for the public sphere, for the government in relation to COVID, and then vaccination infrastructures, which connects them to national ID systems and international travel systems, but also using that to engage in market capture around other areas like more luxury services. And so we wind up with these sort of hybrid entities, which serve government interests, but also sell things and offer access to purely commercial functions, which are not related to government services. And it makes them very hard to conceptualize in a regulatory sense. The third concern that I think we should look at, though, is, as I said in my presentation, purely commercial enterprises, which capture activities which are classically they have democratic implications, that they are so ingrained in the public sphere that we can't conceptualize them as being privatized. For instance, electoral politics is a big one. Everyone can think of the ways in which big tech has been involved in electoral politics in a way that, albeit often inadvertently, constitutes capture in a way that requires regulation, and we can't regulate it because they're not electoral bodies, they're not political parties, they're not governmental, they're not contracting with government. Another way is in information distribution, that if commercial companies become more important channels for information of importance to the public, that we can't get away with not using them anymore. We can't walk away from those companies, and yet they're in no way accountable to us as the public. And they follow a very thin version of corporate legitimacy that's not adequate, that doesn't represent the importance of what they do. So I think these are the things that we need to think about. And the assumption that the market takes preference in these matters becomes very problematic when we think it through in a regulatory way.
Mm-hmm. So, thank you. And my other question was on, you also said that there is this whole concept on fairness, which is meant in a more engineering way. And maybe you could just state again why those technological fixes are not enough.
Mm-hmm. So it's important to say that, I mean, I'm not disrespecting the fact that this conception of fairness is often based in the same assumptions that legal conceptions of fairness are based in, right? They come from this, they have the same genealogy, and that is to be respected and hopefully to be used constructively. But for instance, disparate impact doesn't get us all the way with regard to justice. Right? And the way that we think about fairness in the EU is even less well built up legally, because we don't tend to count people by race and ethnicity, for instance, in the EU. It becomes very hard to deploy the kind of apparatus of fairness that you can even in the US. And in the US, we're finding that it's profoundly inadequate for dealing with AI. We're finding that it answers some of the questions. It answers the quantitative questions about, can we see disparity being enacted by this technology? It doesn't answer the question about what substantive justice looks like with regard to particular populations and how the technology is supporting or getting in the way of that substantive justice. So we can get some of the way towards process using current definitions, current computational definitions of fairness, but they don't get us anywhere towards substantive justice. And that is problematic because that's the sphere in which AI is now starting to operate.
Yeah, so thanks a lot for your answers. We stop now the recording, and for the listeners on YouTube, just thank you for listening also to this talk, and you can also look through our other talks on our YouTube channel or on the website of Netzformer.